When a plaintiff initiates a lawsuit in federal court, they must clear several procedural hurdles before the merits of the case can even be addressed. Two critical, yet distinct, hurdles are personal jurisdiction and venue. Personal jurisdiction answers the fundamental question: does this court have the authority to make binding judgments against this specific defendant? If the answer is no, the case cannot proceed here. Venue, however, operates under a different premise. Assuming personal jurisdiction is established, venue answers the question: which federal district court is the appropriate location for this litigation? Venue dictates where within the federal system the case should be heard. Venue rules are not derived from the Constitution or common law, but are primarily governed by federal statute, specifically Title 28 United States Code Section 1391. This statute only becomes relevant after personal jurisdiction has been successfully asserted. Our next step will be to define precisely what constitutes proper venue under that statute. We now turn directly to the primary statutory basis governing venue in federal civil cases, Title 28 United States Code Section 1391. This section establishes three tiers for determining proper venue. First, venue is proper in any judicial district where any defendant resides, provided that all defendants are residents of the state in which that district is located. This is often called the residence test. Second, venue is proper in a judicial district in which a substantial part of the events or omissions giving rise to the claim occurred, or where a substantial part of the property that is the subject of the action is situated. This is the transactional test. Finally, if neither the residence test nor the transactional test provides a proper venue, the fallback rule applies. Under this third option, venue is proper in any judicial district in which any defendant is subject to the court's personal jurisdiction. Remember, these three possibilities provide the complete framework for establishing venue under Section 1391. We must now delve into the specifics of residency, particularly for non-individual defendants, as defined in Section 1391 subsection C. This definition is frequently tested. For corporations and other entities, residency for venue purposes is defined broadly. A corporation resides in any judicial district where it is subject to personal jurisdiction at the time the action is commenced. This is a critical distinction. Remember that for diversity jurisdiction purposes, a corporation is considered a citizen of both its state of incorporation and the state where it has its principal place of business. However, for venue under Section 1391, the test is purely jurisdictional at the time of filing. It is not about citizenship. It is about personal jurisdiction contacts. This broad definition often makes finding venue easier for entities than for individuals. Now that we understand how residency is defined for venue, what happens if the plaintiff files the lawsuit in a district where venue is technically improper? When venue is improper, the defendant must act swiftly because venue is a waivable defense. Unlike certain challenges to personal jurisdiction, venue must be raised early under Federal Rule of Civil Procedure 12, subsection H, paragraph 1. This means the objection must be included in the defendant's initial responsive pleading, typically the answer, or in a pre-answer motion. The specific procedural tool used to challenge venue is a motion made pursuant to Federal Rule of Civil Procedure 12, subsection B, paragraph 3. This is commonly referred to as a 12b3 motion. If the defendant fails to raise this objection in the required manner and timeframe, the defense is permanently waived, and the court may proceed even if venue is technically lacking. Successfully asserting this motion sets the stage for the next critical discussion: what the court does once improper venue is established. Now that we have established how improper venue is challenged, we turn to the court's primary statutory tools for correcting venue problems. These tools are codified in Title 28 of the United States Code. The first tool is Section 1406, or 28 U.S.C. Section 1406. This statute applies exclusively when the initial venue chosen by the plaintiff was improper. If venue is improper, the court has two options under Section 1406. It may dismiss the case entirely, or, crucially, it may transfer the action to any district court where venue would have been proper originally. This allows the case to proceed without refiling. The second tool is Section 1404. This statute applies only when the venue is already proper under Section 1391, but the court determines that a transfer is necessary for the convenience of the parties and witnesses, or in the interests of justice. Understanding when to apply Section 1406 versus Section 1404 is absolutely critical, as this distinction is a very frequent point of examination on the bar exam. We now focus specifically on transfer under Section 1404 subsection A, which applies when the initial venue is already proper. This transfer is discretionary and is granted only when it serves the convenience of the parties and witnesses, or is otherwise in the interests of justice. The court conducts a balancing test, weighing several factors. On the private interest side, courts examine the ease of access to sources of proof, the availability and cost of obtaining willing witnesses, and the possibility of viewing the premises if necessary. Public interest factors include the administrative difficulties flowing from court congestion in the chosen forum, the local interest in having localized controversies decided at home, and the appropriateness of applying the law of the forum whose law is to be applied. Crucially, the plaintiff's initial choice of forum is given substantial deference. Therefore, the defendant seeking the transfer must demonstrate that the balance of these factors weighs heavily in favor of moving the case to another federal district. We have thoroughly examined statutory transfer under Section 1404, which moves a case from one federal district court to another when venue is proper but inconvenient. Now, we transition to a related, yet distinct, common law doctrine, forum non-conveniens. Forum non-conveniens, or FNC, is an equitable power that allows a court to dismiss an action entirely, even when jurisdiction is proper and venue is technically correct under the statutes. The critical prerequisite for applying forum non-conveniens is the existence of an adequate alternative forum available to the plaintiff, often located outside the United States judicial system. The fundamental difference between these two concepts is the remedy. Section 1404 results in a transfer to a different federal district court, keeping the case alive within the federal system. In contrast, forum non-conveniens results in outright dismissal of the case. Because FNC typically involves moving the dispute outside the United States system, it is reserved for situations where transfer under Section 1404 is not an option, such as when the only suitable forum is in a foreign country. The Supreme Court established the framework for analyzing a forum non-conveniens dismissal in the landmark case of Piper Aircraft v. Raynal. This analysis proceeds in two mandatory steps. First, the court must determine whether an adequate alternative forum exists. An alternative forum is generally deemed adequate if the defendant is amenable to process there, and if that forum provides some remedy for the plaintiff's claim, even if the remedy is less favorable than what might be available here. If no adequate alternative forum exists, the inquiry ends, and the motion must be denied. If an adequate forum is found, the court proceeds to step 2, balancing the private and public interest factors. Private factors include the ease of access to physical proof and the ability to compel the attendance of unwilling witnesses. Public factors involve administrative difficulties, the imposition of jury duty on a community with no relation to the litigation, and the local interest in having the dispute resolved at home. Crucially, the plaintiff's initial choice of forum is entitled to extreme deference. The defendant must demonstrate that the balance of these factors weighs strongly in favor of dismissal to overcome this deference. We have now covered all the necessary components for determining where a federal lawsuit may proceed. To apply this knowledge effectively on an examination, remember the mandatory decision-making hierarchy. First, the court must always confirm that both subject matter jurisdiction and personal jurisdiction exist over the parties and the claim. Second, assuming jurisdiction is met, the court checks statutory venue, primarily governed by Title 28, Section 1391. If venue is found to be improper under Section 1391, the court must utilize Section 1406, which permits either dismissal or transfer to a district where venue would have been proper. If venue is initially proper, the court then moves to the discretionary analysis under Section 1404, weighing convenience factors to decide if a transfer is warranted. Finally, if venue is proper under statute, but the case truly belongs elsewhere, perhaps in a foreign jurisdiction, the court may invoke the equitable doctrine of forum non-conveniens, leading to dismissal. Following these steps provides a clear, comprehensive roadmap for analyzing any location challenge.